Right, so moving on. So let's continue looking at general partnerships, and particularly we'll look at powers and duties of the partners. So in a general partnership, remember it's two or more persons coming together to operate a business for profit. So once the partners have formed a partnership, then what are the duties and powers of these partners? So while in a general partnership, each partner actually consents to being both a principal and an agent of the partnership. This means they have a dual purpose function, where a general partnerships is binding on the general partners through a contract, because whenever a partner is making a decision about the partnership, they're simultaneously acting under control of the partnership, and they're acting within the scope of his or her actual or apparent authority. Because remember, because a partnership consists of two or more people, one partner does not have the unlimited power that a principal has in an agency relationship. Instead, they are a part of the principal. They're essentially together forming the principal. Right? The two partners together are the principal. When a partner acts individually, they're an agent of the partnership. Hopefully that's pretty straightforward to understand. So as a result, while a majority of partners may decide ordinary matters and therefore bind the other partners, a non-routine matter requires a unanimous vote in the affirmative from all of the partners. So what are the duties that partners owe the partnership? Well, there's two. There's the fiduciary duty of loyalty and the fiduciary duty of care. The duty of loyalty is similar to the duties that an agent owes a principal while in an agency relationship, and that would be not competing with the partnership, not acting as a party with an adverse interest, and not exploiting a partnership opportunity or secretly using partnership assets. Essentially, it means that a partner shouldn't go out and do business that would compete with the partnership that that person is in. Furthermore, if there's a business opportunity, maybe if the partner chooses to not engage with that business opportunity and instead uses it and usurps that opportunity for their own organization, that would be a breach of the duty of loyalty. The duty of care is easier to understand. That one is partners are not to engage in knowing violations of the law, intentional wrongdoing, or act in a grossly negligent manner. Pretty self-explanatory and very similar to the agent's duties to the principal in an agency relationship. So that generally covers our partnerships, our general partnerships. Next, we'll look at a special form of a partnership called a limited liability partnership, or an LLP. So an LLP is simply a general partnership with the added legal protection of limited liability. So it's a favorable form of organization for professionals who have not yet incorporated. So in many states, the registration of a limited liability partnership requires some sort of proof that the persons that are creating this LLP are qualified as professionals that are defined via statute. So taking New York, for example, the only way to form an LLP in the state of New York is to be a licensed attorney, a licensed CPA, or some sort of other professional licensor scheme that allows the creation of a general partnership with the protection of limited liability. Therefore, an LLP must have a statement of qualification filed with the Secretary of State and the maintenance of professional liability insurance. So all the partners in an LLP are considered general partners, much in the same way a regular partnership counts all the members of a regular partnership as a general partner. So in most states, liability is limited for all partnership obligations, including those resulting from contracts. Therefore, people that are a part of a limited liability partnership have more protections about personal liability when it comes to the partnership's debts or obligations. And usually, a full shield statute imposes liability only to the extent of the assets of the limited liability partnership, with some exceptions. So, some of those exceptions are obligations in which a partner personally guaranteed or incurred, or wrongful acts. Sometimes also, a partner who is an immediate supervisor is liable for the wrongs committed by their employee while in the scope of employment. That's very similar to the vicarious liability that we learned as it comes to employer liability for the tortious acts of an employee. So just think of a limited liability partnership, or LLP, as a partnership or a general partnership that has this added protection of limited liability. This will be different from a limited partnership that we'll go into in this class as well. So another special form is a joint venture. This is not technically a partnership per se. Instead, a joint venture is simply a contractual agreement that goes beyond the bounds of national commerce, or although it could solely exist in national commerce, but it's mostly seen and common in international commerce, where the actual legal apparatus for the designations of these business entities are not uniform. So simply, a joint venture is just an association of persons who come together to do a certain task or undertaking in order to make a profit. And generally in the US, the federal and state governments will treat a joint venture as a partnership in most cases. So just keep that in mind. So lastly, we're going to look at a limited partnership. So this is contrasted with a general partnership, a LLP, and a joint venture that we just went over. A limited partnership is a specific type of partnership in which there's one or more general partners that are a part of this organization with one or more limited partners. So what are each of these things? So a general partner is simply the same as a general partner in a regular partnership, in which there's full personal liability for debts of the partnership. And keep in mind here that a business entity may be a partner in a limited partnership, whereas in a general partnership, the partners must be individuals. In this case, this would be a hybrid between a human-based general partnership and a entity-based corporation or limited liability company. Therefore, it's called a limited partnership. So the general partner is the same, but the limited partner is what makes this type of entity different from a general partnership. So in a limited partnership, there's something called a limited partner. The limited partner is generally an investor and by default not a manager or an agent of the partnership. Instead, a limited partner contributes cash, services, or other property to the partnership in return for some sort of allocation or distribution of profits. The limited partner doesn't manage the limited partnership in any way, nor does the limited partner have a fiduciary duty to the limited partnership. So another difference is that a limited partnership is formed with a written certificate of limited partnership filed in the state where it's organized. And by doing this, it gives creditors notice of the limited liability of the limited partners. And without such a filing, the entity is treated as a general partnership, which doesn't require a writing filed in the state. So what about the operation? How is it different from a general partnership? Well, it's very similar to a general partnership, except that when the profits and losses are allocated, whether by quarter or by a set time trigger, the basis of the value of those contributions made by the partner then is used to calculate how much that partner gets in terms of profits and how much the losses are attributed to them. So it's in essentially just think of a limited partnership as having a special class of partner embedded within its structure, and the profits and losses are not allocated equally by default in the way that a general partnership is. Instead, it's based upon the value of the contributions actually made by the partners coming in. And this sort of trade-off allows the limited partnership to have more advantages as it comes to liabilities and rights. What are those? So, a limited partnership has the same sort of legal protections for the general partner as a general partner would have in a general partnership, except a limited partner has less rights, but they do have some. So some of the rights that a limited partner has would be the ability to propose and vote on partnership affairs that don't directly control partnership operations. So they can do so on things about maybe whether or not to engage with a particular potential client or explore a potential business opportunity. They just can't vote on either the removal or the addition of another general partner. They're only a limited partner. They can do business with the partnership by lending it money. They have reasonable access to the partnership records, and they can inspect and copy those on a reasonable basis. They can also assign their interest in the partnership as a limited partner to somebody else, but it doesn't mean that the person that they assign that interest to becomes a new limited partner. Instead, that assignee simply gets the right to get the interest or the benefits of the limited partnership, whereas the limited partner, the original person that assigns their interest, they still remain as a limited partner. And lastly, a limited partner is liable only for his or her capital contribution. Their liabilities only extend to that amount. And the limited partner has no right to participate in the control of the business, because control is participation in day-to-day management decisions. A limited partner simply gives money to the limited partnership, and the general partners are the ones that do all of the control decisions and make all of those general decisions that require unanimous consent. So hopefully this makes sense. Is going all the way back, just so we get a good grasp on this, is you have the sole proprietorship, which is simply one individual doing business. They take all the risk and they're the ones that file their own taxes. Then you have a partnership, which is what we went over. And inside of partnership, you have the general partnership, which must be between two human beings. You have the limited liability partnership, which must be between two or more human beings that are professionals. You have a joint venture, which doesn't look to see whether it's a business or a human being, and is used internationally. Then you have a limited partnership, which also has general partners that must be human beings, but limited partners that could be businesses. Hopefully that makes sense. If you have any questions about this, feel free to reach out to me, because I know there's a lot of acronyms and things to memorize in this particular topic. Thank you.